The laws that created rooms for periodic elections into 1,695 elective public offices in Nigeria, which the Independent National Electoral Commission (INEC) is empowered to conduct, also allows for room for election petition tribunal, equivalent of the High Court, to handle judicial petitions arising from the conduct of such polls, with a view to determining the authenticity or otherwise of such polls. Such petitions are filed by aggrieved parties. Welcome to this week's edition of Law Weekly. I'm Victoria Ido. Today, we will be looking at the elections coming up on the 14th of February and the role the judiciary will play, especially as regards the election disputes arising from pre- and post-election matters. Our guest on the program today, Mr. Malaki Ugumadu, speaks on the upcoming elections. But first, let's take some headlines.
For over 1 hour, the Secretary to the government engaged the leadership of the Judiciary Staff Union of Nigeria over its strike action, which was suspended after 3 weeks. At the end of the meeting, Senator Ayim Pius Ayim promised that the government will comply with the judgment of the Federal High Court.
I could see the press anxiously asking for the written undertaking. And I want to clarify that for the first time, this undertaking is reached by sheer consensus and clarity of understanding of what the issues are. Like the President of the Bar said, it's a matter of implementing a constitutional provision. And for us at the federal government, we are certain that ours is a law-abiding government, and we shall have no issue making sure that the Constitution is respected.
The president of the Nigerian Bar Association, who attended the meeting, commended the union for its action, saying the strike is a selfless one.
The strike at the federal level was called off on the basis of the assurances and commitments given by the federal government. And unfortunately, we are here today. The Attorney General of the states were not able to be here. So I believe it depends on how you're looking at it. It's either 6 or it is half a dozen. You can say you have not called off the strike, but I would say you have called off the strike on the condition that there's commitment from the states to comply with the Constitution.
With assurances from the federal government and the NBA president, the president of the judiciary workers reaffirmed the union's commitment to end the strike, but warned that the strike remains in force at the state level.
The strike continue in all the states until that state gives us a similar commitment. Then we will now suspend the strike in that state.
Although the strike remains in force at the state level, it was a happy ending for the workers who sang solidarity songs, having gotten an assurance from the government to comply with the judgment of the court. The judgment of the court affirmed the financial autonomy for the judiciary and abolished its piecemeal funding by the executive arm.
The Federal High Court in Lagos adjourned the trial of a former bank PHB PLC Managing Director, Mr. Francis Atuche, till February the 27th. Atuche is standing trial alongside a former defunct Spring Bank PLC Managing Director, Mr. Charles Ojo, on an amended 45-count charge bordering on alleged 125 billion naira fraud. Justice Saliu Seidu adjourned for mention after Mr. Ojo's lawyer, Mr. Osahon Idemudia, said he needed more time to prepare his client's defense. Economic and Financial Crimes Commission lawyer, Mr. Kemi Pinero, did not oppose the request. EFCC rearraigned Atuche and Ojo on charges of acquiring Bank PHB's shares using depositors' funds. They have pleaded not guilty to the 45 counts of conspiracy, reckless granting and approval of loans and money laundering between September 1, 2006 and 2009. A 29-year-old man, Abiodun Elemoro, has been sentenced to life imprisonment for dealing in heroin. Justice Rita Ofili Ajomogobe of the Federal High Court convicted him on one-count charge of dealing in 30.5 grams of the banned narcotics. Elemoro, who pleaded guilty, was arraigned on April the 26th last year. He was arrested with a banned substance by men of the National Drugs Law and Enforcement Agency, NDLEA, at Palm Church Street, Lagos Island, Lagos. She ordered the NDLEA to destroy the substance if there is no appeal against the judgment. Some shareholders of the defunct bank PHB PLC have sued the Central Bank of Nigeria at the Federal High Court in Lagos over the alleged illegal transfer of their shares to Keystone Bank without compensation. The plaintiffs are demanding 38.6 billion naira from the defendants, being fair compensation to them for the value of their investment in Bank PHB PLC. They also want 20 billion naira as damages for the loss of value of their investments in Bank PHB. Keystone Bank, Attorney General of the Federation, Nigeria Deposit Insurance Corporation, and the Asset Management Corporation of Nigeria AMCOM are other defendants in the action. The plaintiffs said NDIC on August 5, 2011, wrote the Managing Director of Bank PHB, informing him that the bank's assets and liabilities had been transferred to Keystone Bank. Justice Mohammed Yunusa adjourned till March 2nd for ruling.
Politics, they say, is a game of numbers, but in this game, 2 plus 2 might not necessarily give you 4. It is a complex game. Some call it a dirty one. In fact, it is a rowdy world. They never agree. They always have dissenting opinions. One thing is common to them all. It is their interest, and that is what affects you. Our business on politics today is to dissect the issue.
What's different from what you did?
Oh, the difference is that we passed 600 resolutions about this country.
So you can get a sense of it all. Watch Politics Today live, Sundays 8 p.m. only on Channels Television.
When a judicial petition is filed at an election petition tribunal within a stipulated time frame, the referred polls is deemed validly conducted. Matters that are brought before the polls tribunal are matters that have to do with the conduct of the proper elections. Matters deemed pre-election matters, such as nominations of candidates, are filed and handled by ordinary high court, which stretches to the apex court. Those are some of the issues we discussed with my guest, Mr. Malaki Ogumadu.
Let me take it first from the standpoint of the concept of election, to reckon that election is first and foremost a context. And that is why people say it's a game. A contest between contenders for political power and political offices. And once that is given, it stands to reason that corollary to that is the disputation that will necessarily arise from that contest. In other words, there must be a winner, there must also be a loser. But what has given rise, which has become the foundation upon which you have election petitions, is the several irregularities, the breach of procedure, and the non-compliance of the rules and conditions of the game. These are essentially what gives rise to election petitions.
A candidate who has been aggrieved with an election, what would be his grounds for an election petition?
Well, the grounds are clear. Under Section 134 of the Electoral Act, if I'm not mistaken, and there are basically 4 grounds. 1, if the election itself is tainted by serious irregularities, including corruption, fraud, and non-compliance with the rules. That could be one of those grounds. Secondly, if the person who was declared the winner did not secure the majority votes, valid votes, cast in that election. Indeed, if the person, as at the time the person who was declared the winner as at the time of the election, is actually disqualified by reason of his qualifications to contest that election, that election can be challenged. So those are the basic grounds upon which a litigant who intends to challenge the purported victory of a candidate can proceed to court. But the difference is that whereas with respect to intra-party action, which is what we usually call pre-election matters, you proceed to the Federal High Court, which is the express provision of Section 87, subsection 10. With respect to the election proper, the contents of the election proper, you must necessarily proceed to the election petition tribunal, which is provided in the relevant provisions of the Constitution, including Section 285.
How do you prove that an election has been marred with irregularities?
This is a very sensitive question. And I think that what has become very challenging is the state of the Electoral Act, which imposes, if you like, the burden of proof on the petitioner to prove that indeed this election was marred with irregularity, and convince the courts beyond that proof that but for that irregularity he ought to have secured victory. In other words, if you remove the acts of irregularity, if you discountenance what you claim went wrong, would you have also won the election? We are saying that that is double jeopardy for the petitioner. Yes. And that INEC, who are usually respondents or defendants in both pre- and post-election petitions, should be made to convince the court that the election they conducted met the standard requirements. And that once that becomes the case, this whole mischief of perpetrating those irregularities and challenging your opponent to go to court will gradually begin to simmer down. And we make this point in addition to the fact that you don't just control these things merely by these legislations that are not activated. If you look at Section 150 of the Electoral Act, it empowers INEC to prosecute electoral offender